The Uniform Civil Code is back in the news. Not that it was anytime away from the limelight, but debates on Uniform Civil Code have been going on since 1951 when the Hindu Civil Code Bill was introduced in India's parliament. This bill sought to provide a codified personal law applicable to Hindus throughout the country. Despite stiff opposition from conservative Hindus within and outside of the parliament, the bill resulted in the Hindu Marriage Act, Hindu Succession Act, Hindu Minority Act and Guardianship Act. It is Hindu Minority and Guardianship Act and Hindu Adoptions and Maintenance Act. And all these acts were passed in the parliament during the period 1955 to 1958. As India is a pluralistic society, this was only a first step towards the formulation and implementation of the Uniform Civil Code or UCC, which would be applicable to all citizens of India as sanctioned in Article 44 of the Constitution of India. As you know, Article 44 relates to the directive principles. While the Hindu community eventually accepted and abided by legislated laws mentioned above, other communities became wary of the UCC. Debates on UCC blew hot and cold over the decades, but things really hotted up in 1980 when the Supreme Court granted maintenance to Shah Bano, a Muslim woman divorced by her husband. Muslim conservative groups protested vociferously and the Rajiv Gandhi government succumbed to the pressure. It legislated the Muslim Women Protection of Rights on Divorce Act in 1986, which limited the maintenance duration for Muslim women. Though it halted the storm, it provided a boost to regressive elements not only in the Muslim society but also in other communities. Ever since then, successive governments have been dodging the legislating of UCC. They prefer to use the issue to garner votes, and the BJP has been using this particular issue for furthering its polarization agenda in the country. But what exactly is Uniform Civil Code? What are its features? How will it affect various communities in India? Are the minorities in India justified in their assumption that UCC is a threat to their cultural identity and traditions? There are counter arguments in favor of UCC as a harbinger of a modern, tolerant, pluralist society that will make a clean break from the medieval precepts and practices. So we need to understand the history and salient features of UCC. The Uniform Civil Code UCC refers to a set of common laws governing personal matters such as marriage, divorce, inheritance, adoption and maintenance for all citizens irrespective of their religious affiliations. The aim of implementing UCC is to provide equal rights and treatment to all individuals, regardless of their social background, and to promote gender equality and social justice. In fact, gender equality has been an issue with progressive elements in the society even before India's independence. Women activists in India have been fighting for their rights for almost a century now. It was thanks to their insistence that the Nehru government legislated laws like the Hindu Marriage Act, etc. Today, India has a diverse legal framework for personal laws which are specific to different religious communities. These personal laws govern matters such as marriage, divorce, inheritance, and adoption. Hindu personal law applies to Hindus, Buddhists, Jains, and Sikhs. It is derived from ancient Hindu texts, customs, and judicial precedents. Muslim personal law is derived from the Sharia. It includes different schools of thought and interpretations, leading to some variations in its application. The Christian personal law applies to Indian Christians. It is largely based on Christian religious principles and can vary depending on the denomination, region and community. Parsi personal law applies to the Zoroastrian community in India. It is mainly based on the Parsi Marriage and Divorce Act of 1936. Jewish personal law applies to the Jewish community in India. It is based on religious customs and principles followed by the Jewish community. Is Muslim law unique and unalterable? Opponents of UCC in the Muslim community argue that Muslim personal law in India is unique in several ways. It applies to Muslims in India. It is not confined to a particular state or region, but to all Muslims across the country. The law allows Muslim men to have up to 4 wives, subject to certain conditions. Muslim marriage ceremonies follow specific rituals and practices, including witnesses and the offer of a meher, also known as dowry, to the bride. Here the dowry is either given to the bride or it is in a written contract it is promised that in case of divorce or separation this meher would be given to the bride. The law also provides different modes of divorce, including talaq, which is a divorce initiated by the husband, khula, divorce initiated by the wife, and mubarak, which is mutually agreed divorce. These divorce procedures have specific requirements and processes which may differ from other personal laws. It provides fixed shares for heirs such as children, spouses, parents and other relatives based on their relationship to the deceased. It includes provisions for maintenance, which is known as nafaka, and custody of children after divorce. These provisions may differ from those in the other personal laws. The Muslim personal law is primarily based on the Sharia, which is derived from the Quran, hadiths, which are actually sayings and actions of Prophet Muhammad, and legal opinions of Islamic scholars. Therefore, it is unalterable and cannot be challenged. Contrary to the arguments given above, the application and extent of Sharia law vary among different countries. While some countries incorporate elements of the Sharia into their legal systems, no country follows Sharia law exclusively or in its entirety. Sharia law is typically applied in varying degrees in matters such as family law, inheritance and personal status issues. Interpretations and practices of Sharia law can differ within and among different Muslim majority countries. Here are a few examples. Iran's legal system is based on a combination of civil law and Islamic law. The country follows the Jafri school of Shia Islamic jurisprudence, which heavily influences its legal framework, including family law and criminal law. Saudi Arabia is governed by a legal system based on a strict interpretation of Sunni Islam. Sharia law plays a central role in the country's legal system. Its religious courts apply the law to family matters, criminal offences and public behavior, among other aspects of life in that country. Pakistan's legal system is a mix of common law and Islamic law. Sharia law is applied primarily in matters related to family, inheritance and personal status issues for Muslims. The country has Islamic courts that handle these matters. Malaysia has a dual legal system with civil law and Islamic law operating concurrently. Sharia law applies primarily to Muslims in matters related to family law, inheritance and personal status issues. Sharia courts handle these cases in cases for Muslims, while civil courts handle non-Muslim matters. UAE has a mixed legal system that combines elements of civil law, Sharia law and customary law. Sharia law is primarily applied to personal status matters such as marriage, divorce and inheritance for Muslims. The extent of the application of Sharia law can vary even within countries, depending on factors such as regional practices, legal reforms, and the influence of cultural and societal norms. Given the complexities and diversities in India, it would indeed be a challenge to formulate a uniform civil code that would be acceptable to all. Yet, India cannot anymore afford to have a plethora of personal laws that override civil laws and cause great confusion. The laws need to be just, fair, and simple to understand as far as the Indian citizens are concerned. This will reduce disputes and litigations significantly. The court verdicts may also cause less confusion and heartburn among the litigants. Goa already has its own version of the UCC, which is called the Goa Civil Code. It is also known as the Goa Family Law. It is a unique set of laws that govern personal matters such as marriage, divorce, adoption, and inheritance for the residents of Goa. Unlike the personal laws in the rest of India, the Goa Civil Code is not based on religion. Here are some key details of the Goa Civil Code. A married couple jointly holds ownership of all the assets owned or acquired by each spouse. In case of a divorce, each spouse is entitled to a half share of the assets. Parents cannot disinherit their children entirely. Muslim men who have their marriage registered in Goa cannot practice polygamy. Equal property rights for both sons and daughters. Every birth, death, and marriage has to be compulsorily registered. In case of a divorce, each spouse is entitled to a half share of the assets. However, the law also allows prenuptial agreements, which may allow the spouses to hold the assets acquired before marriage separately. Such agreements cannot be changed or revoked. The Goa Civil Code can be treated as a model for the construction of UCC because of its forward-looking approach to personal laws, emphasizing gender equality and individual rights. The UCC ought to be easy to understand and easy to implement. It is time for resolving legal complexities and inequalities arising out of different personal laws in the country. The argument that polyandry and polygamy are prevalent among Hindus and Muslims only supports outdated and regressive customs that have no place in the 21st century India. There is no merit in preserving obsolete traditions, conventions, and practices which violate the principles of natural justice and equality before the law. Thank you for being with me. I shall come back with another video very soon.